Yeah, I want to talk with you about MDDC practices, also called integrated practices. These are practices where MDs and chiropractors work together. Usually it's a practice that's owned by a chiropractor that sees that their patients need the services provided by an MD or a DO. So they want to figure out, well, how do I expand the list of services that my practice offers to include medical practice services. Could be interventional pain, could be emergency medical condition assessment, could be anything like that. So how do I do it? Well, Florida, and I'll speak specifically about the Florida issues in a moment, but you have to understand in terms of the general perspective of these practices, how the regulators look at them. They basically think that the reason why chiropractors want to add medical services is so that they can skirt and violate applicable law. So the presumption on these practices is not good. They'll think that really what you want to do is provide services that patients don't need, and this is going to be a vehicle to generate cash flow when there's no medical necessity. That's the presumption. It's the presumption of regulators, it's the presumption of payers as well. So it's extremely important that the model is set up properly and that it's operated properly. There's two versions of the model. One is what I call a direct services model, which is something you can do in Florida, but not every state. This allows a chiropractic practice to hire an MD or a DO and pay the MD or DO a salary, and all the services are billed through the chiropractic practice. It's a very simple model, it's a very common model, and you want to make sure that you understand the laws as they pertain to employing physicians and compensating them. The other model, which is more prevalent in terms of the practices nationally, is what we call a management model. This is what we do in states where an MD can't be employed by a chiropractor. These corporate practice prohibitions are common in the country. In fact, they're the dominant legal impediment to doing MDDC practices. So what do? Management model. The chiropractor establishes a management company. The management company enters into a contract with the physician practice. It sounds pretty simple, but I want to let you know about those two models: direct services, management model. In Florida, we have some state issues you need to be aware of. If you want the MD to own your practice with you, then you have to get a healthcare clinic license. It takes 90 to 120 days. Why do you need to do this? Because state law is a little bit tweaky, and the state law of every state where you're going to want to do an MDDC practice is unique. Corporate practice prohibition, state law prohibitions on hiring MDs, and any state law licensure issue as it relates to a practice that's owned jointly by an MD and a DC, like Florida has one. Again, healthcare clinic license, HCCL, required in Florida, takes time. So you're going to need to know, what kind of model am I going to use? What is the compensation that's permissible in the state? And are there any other state licensure issues that I need to be aware of? Finally, payers. How do payers respond to the model that you're selecting? You need to know that before you set your model. In Florida, for example, some payers, not most of them, but some of them, do not like to pay a chiropractic practice for medical services. You have to understand that, and you have to create a structure that allows you to provide both medical and chiropractic services in a way that payers will say, fine, and they pay for the medically necessary services.